Thank you. Shri Pratap Sarangi ji.
Honorable Chairman, sir, I offer you my heartfelt thanks for having allowed me to participate in this revolutionary amendment bill. Sir, our Honorable Prime
Just
Minister...
a minute. Honorable members, if the House agrees, the time may be extended by 1 hour for this bill. For discussion. So. Thank you. Please.
Sir, I am thankful for having allowed me to participate in this Coastal Aquaculture Authority Amendment Bill 2023. Sir, our Honorable Prime Minister Shriman Narendra Modi ji injected new life and spirit and vigor into the fishery sector, aquaculture sector, which was long forgotten and was not visible during the previous governments. Probably it was unimaginable to apply this department for the economic growth of our country. The budgetary allocation in the previous governments to this department shows how neglected this department was. Under the able leadership of a great champion like our Honorable Prime Minister Shriman Modi ji, a revolutionary scheme like Pradhan Mantri Matsya Sampada Yojana has been introduced to enable our fish farmers, fishers, and all the stakeholders working in the field to stand on their own feet and contribute for the economic growth of our country. Sir, this amendment became a necessity, became inevitable. We know coastal aquaculture, mostly in the form of brackish water, shrimp culture, witnessed rapid growth in 1980s and 90s. This growth, mostly unregulated, drew widespread concern for environmentalists and matter went to Supreme Court. The Supreme Court, in its judgment dated 11th December 1996, in writ petition number 561/1994, Sri Jagannath versus Union of India, held that shrimp aquaculture is an industry and hence covered by the prohibition imposed in paragraph 2(1) of the CRZ notification 1991. Accordingly, it ordered, among other things, that no shrimp culture pond can be set up within the coastal regulation zone, that all shrimp culture industries ponds operating in CRZ are to be demolished before 1997. That central government shall constitute an authority under Environment Protection Act 1996 to deal with the situation created by the shrimp culture industry and to regulate it as per precautionary principle and polluter pay principle. The operational part of this judgment is very, very pathetic. Sir, accordingly, many shrimp culture units were closed, and to avoid this, an act was formulated, and thus the Coastal Aquaculture Authority Act 2005 came into existence. Sir, but this act was not sufficient. We know how persons engaged in the field of aquaculture suffered, and besides the definition was so narrow that the modern developments like seaweed culture and others which were not known by that time, and our Honorable Modi ji popularized these concepts, were not included in the definition. So that necessitated for the amendment. The CA Act has specifically excluded coastal aquaculture zone from the purview of CRZ notification. The recent NGT judgment has given a different interpretation and has opened the door for more litigations. Unless this is addressed quickly and suitably, it will be difficult to attract new investments. Besides that, simplification of the procedure of registration was inevitable. Many of the provisions with respect to registration are too rigid and need to be reviewed. Similarly, a number of administrative procedures laid down in the Act need revision. For example, there is a need to clearly define the powers of member secretary under the Act for administrative efficiency and accountability. In the CA Act, there is this provision of imprisonment for a period up to 3 years for carrying out coastal aquaculture without registration. Sir, for minor slips, omissions, criminalizing the total affair and sending people to jail, poor people to imprisonment, is very serious harassment to the fishers and fish farmers. This appears to be a very harsh punishment for an offence of purely civil nature. Hence, it has been proposed to replace the same with suitable civil instruments, such as penalty in line with the principle of decriminalizing the civil transgressions. A recent order of the NGT, dated 29 September 2022, has ruled that hatcheries cannot exist within 200 meters from the HDL, citing the provision of CA Act. Further, they need to be situated mostly within 200 meters from HDL to ensure steady supply of saline water, which is now a known development area. Accordingly, relevant provision in CA Act 2005 need to be suitably amended to permit establishment continuation of hatcheries. Sir, but over the time, definition of coastal aquaculture has broadened beyond shrimp aquaculture, which prompted the government to bring this amendment. Secondly, the Act of Coastal Aquaculture 2005 was addressing the issues arising out of 1991 CRZ notification. Subsequently, CRZ notification had been amended in 2011 and then in 2019. So there is a legal ambiguity whether this Act will override the subsequent CRZ notification or not. To remove this ambiguity, this bill has been proposed, amendment has been proposed. Thirdly, there are some administrative issues like how the Coastal Aquaculture Authority will move forward in certain situations. It was not fully described. So, in order to bring clarity to this, we have tried to create or amend some provisions to bring some definitiveness into the Act so that authority runs smoothly. For example, to make its member secretary function like CO, it has been tried to insert some provisions. Fourthly, when this Coastal Aquaculture Act was made, it was thought that it only of shrimp farms, but later on it is found that there are ancillary activities such as hatchery, where shrimp seed get produced, without which coastal aquaculture is not possible. Whether hatchery is included in the coastal aquaculture or not, there are certain ambiguities. Through the amendment, this ambiguity is expected to be removed. The main objective of this Coastal Aquaculture Authority will are to harmonize CA Act with the CRZ notification issued from the time to time and to treat the registration granted under CA Act as a valid permission under CRZ regulations to keep coastal aquaculture outside the prohibitions imposed by CRZ notification, to reduce the regulatory compliances burden without diluting the core principles of environment protection in coastal areas, to remove difficulties and ambiguities in the Act for effective implementation, and for promoting ease of doing business, to decriminalize the offences under the Act, and to expand the scope of the Act to bring all coastal aquaculture activities under its ambit. To cover all verticals and activities of coastal aquaculture, including hatcheries and aquaculture inputs. To permit hatcheries, broodstock multiplication center and nucleus breeding centers within the no development zone, sync with the CRZ notification section 30(8). To permit activities like cage culture and seaweed cultivation in the creeks, rivers and breakwaters within the CRZ zone. To replace imprisonment provision under section 14 of the Act with a combination of suitable monetary and other penalties. To make provisions for authorization of officers. To impose penalties against use of banned antimicrobial agents to pharmacologically active components in coastal aquaculture. To provide for recovery of unpaid cost and penalty as arrears of land revenue. Sir, it is apprehended that this will encroach into the rights of the provinces. This is not a fact, sir. Sir, it is clear that up to 12 nautical miles from the which states will make legislation, and up to 200 nautical miles central will make legislation. But this is a question of environmental protection and protection of the fishers and fish farmers, which is the exclusive right of the union government. This is in the interest of the states as well. So this amendment is in the interest of our fishers, fish farmers, our processors, and so major amendments are proposed mostly to decriminalize the offences which are civil in nature, removal of the provisions of imprisonment under Section 14, substitution of imprisonment with monetary penalties, provision for authorization of officers. And, sir, what was the problem? If the chairperson is not present, for years together application for registration, renewals were pending. But here amendment has been made. The chairperson may nominate somebody to decide these cases, and people will not have to wait. Sir, Section 13 provisions have been made for authorized officers and adjudicating authorities. Condonation of delay, earlier it was, if it is not filed in the right time in the fixed date, that was not considered at all. The case was lost. But here condonation of delay in submitting the renewal application under Section 30 is also provided. This will ensure that the farmers are not put into undue harassment and difficulties because of minor slips. Provision for providing new certificate in case of mutilation, damage or loss, and for effecting changes in ownership, etc. is also provided here. Validation of the meetings of the authority during the absence of the regular chairperson of the authority. Minor revisions in composition
Please
of the
conclude.
authority. Sir, provisions empowering the authority to appoint committees for efficient discharge of duties. Sir, these are the revolutionary amendments which has been brought in this amendment. So I appeal to all to pass this amendment unanimously. Unfortunately, our Congress and other people are not here to discuss in the interest of the people. They have left. But this is a sorry figure. Anyway, I request to pass.
Shri Lav Sri Krishna Devaraya.